Good afternoon, everybody. This is Jason Gold, NABT President. You can't see me on the screen because apparently there's an issue with the GoToWebinar video server. So this looks like it'll be an audio only event, but we will carry on. And we have a great program for you this afternoon. This is the third NABT virtual meeting that we're having since the COVID-19 crisis began. We have a great panel, and let me introduce the panel and we can get right to work. We have Kelly Hagan, Chapter 7 trustee and newly minted Subchapter 5 trustee. Kelly sits in Traverse City, Michigan. She's a past president of NABT. Gary Seitz, Chapter 7 trustee in Philadelphia, and Gary is on the board of directors of NABT. We also have past president Tamara Ogier, who is also now a Subchapter 5 trustee. Tamara's been on the Chapter 7 panel for some time, also past president of NABT. We have two special guests as well, Lynn Tavener and Paula Barron, who are trustees in Richmond, Virginia, and also they're both Subchapter 5 trustees as well. So we're ready to begin, and without further ado, let me turn it over to Gary. Gary?
Jennifer, before I get started, can you confirm that you're able to show on the screen the rules?
Nope, I cannot. I cannot share a screen or anything. I was just trying to see if I could do anything, and I cannot.
Okay, so let me remind everyone of basically the rules of the system, which are going to be somewhat modified since we don't have a video connection. The first thing to keep in mind is that if we think that you can raise your hand to ask questions, and when you do that, at the appropriate moment, we'll try to wave you in. Unmute your microphone so that you can ask questions. We'll try to give a shout out to you when we're doing that to give you a warning. Make sure your system is set up for audio so that when we do that, you'll be able to participate and ask questions. If you do speak, we ask that you try to keep your comments under 2 minutes. You can either raise issues of your own or ask questions of the panelists. Full dialogue is encouraged. And when I say raise your hand, I don't mean raise your hand where you are. There's a little feature on the side of, on the dashboard on the right-hand side of your screen for most of you, where you have to press the little hand that'll flag us that you have something that you might want to bring to our attention. There's also a chat feature towards the bottom of that same box. If you prefer, you can enter your comments and questions in the chat box. We'll monitor those and bring those into the discussion at the appropriate moments. We'd like to try to complete this meeting by 5:00 p.m., so try to keep that in mind. The recording of this meeting and the past meetings that we've done, the two previous meetings, can be found on the NABT website, nabt.com/COVID_19. So you can check that out afterwards. Since there's no video cameras here recording us, we don't think there's any recording you, so don't worry about that. And with that, I will pass it over to Kelly Hagan. Kelly?
Kelly, you're muted.
Okay, now you can hear me. So I would note that I can see Jennifer's screen now. The panelists are now listed, so perhaps we're going to start seeing more video. So we're going to just take a few minutes at the beginning to talk about some updated information for best practices for our 341 meetings, share any new ideas or brainstorm ongoing issues that we're having in conducting our 341s or administering our cases in the course of this COVID pandemic, excuse me. Tamara, I think you were going to provide us some thoughts on telephonic 341s.
Yeah, I mean, we've had a couple of sessions talking about doing Zoom 341s, but in Region 21, and I think in a lot of other regions, they haven't authorized Zoom. So we're doing them all telephonically. And I've had 2 telephonic 341s this week, 2 calendars, I should say, all day Tuesday and half a day today. And generally, I'd say it went pretty well. There was a lot of concern about how we were going to deal with IDs in telephonic meetings. So that was really what I wanted to talk about, because it actually went pretty smoothly. We had emailed all of the debtors' attorneys prior to the meetings and asked them to submit the IDs directly by uploading them to our system. If they weren't able to do that, we gave them the option of emailing them, but we really didn't want them to do that because that's really not a secure method of delivery. Then during the creditor meeting, we first asked the debtor, are you the person that filed this bankruptcy? And is the address and social security number listed on the petition your correct address and social security number? And then we asked the debtor's attorney, can you identify the IDs that you inspected? Then can you indicate that the IDs appear to be valid documents that identify the debtor? And then can you confirm that the information on the IDs matches the name and social security number that appears on the notice of meeting of creditors? It didn't take long before all of the debtors' attorneys were pretty well versed in what we wanted them to respond, to the point where most of the mill filers that I deal with now, as soon as I ask them about IDs, they have something that they say that responds to all 3 of those questions. And it went very smoothly. I had a couple of cases that were going to run over the 10 minutes. So I just said, all right, we've got to pause this meeting now, and I want you to call back in at the end of my calendar. And I concluded them later. I had a couple where they hadn't produced the right tax return. In other words, they had filed one for 19, but it had only given me 18. So I also tacked those onto the end of my calendar. And honestly, I would say the most difficult thing is that I was completing the meetings in about 7 or 8 minutes. And then that 2 or 3 minutes in between is just enough time to get distracted and worry I'm going to be late starting the next meeting. But it went very smoothly. And I would say the key was preparation. I normally don't have a script that I follow for 341s. I just have the questions memorized. This time I printed out the list. It was much harder to keep track of where I was without somebody looking at me. And then snacks and bathroom. There's not a lot of time for that. So I wound up bringing like several bottles of water in here and had them set up and ready to use. And anytime I had a spare 3 minutes, I went to the bathroom because otherwise there was just no opportunity. And that's really all of my observations, having done it twice this week. I thought it went pretty smoothly.
Great, thanks. Gary, have you had an opportunity to do any more telephonic meetings since our last discussion?
So I've done 2 days of meetings, predominantly by Zoom, but in both of those meeting days, there were some individuals that could not participate by Zoom, and so we did telephone instead. And very similar to Tamara's experience, the attorneys were able to sort of figure out what I needed pretty quickly. It took longer than usual to get everything going, but this experience is basically the same. In our district, we are allowed to use Zoom, but there are some trustees that prefer to use the conference lines provided by the U.S. Trustee's Office. So, you know, we're going both directions here.
Any other thoughts from our panelists about updates to what we've already discussed in our last couple of sessions, or what you're seeing coming? I will share with you that in our district, which is Region 9, Western District of Michigan, we had a conference call today with our Assistant U.S. Trustee, and it looks likely that we are expecting to do our meetings remotely even through June, perhaps. And I've been given the authority to notice up my May meetings as remote. And we're doing most of ours by Zoom in my district, I think.
This is Len Tavener. I am in Region 4 in the Eastern District of Virginia, and our U.S. trustee has determined that he would prefer that we not use Zoom or any video capability at this point in time, and has instead instructed us to do the telephonic only. I will say that some of the debtors' attorneys are taking it upon themselves to Zoom in with their clients and have them together when they call in for the telephonic 341. And the one thing that we are doing a little differently on the telephone line is ever how many are scheduled for an hour, usually 10 to 15, everyone gets the telephone number and is told to call in 15 minutes in advance. And so the debtors and their counsel are the ones that are waiting on the line, so that if we're able to conclude quicker, then there is a little more time for a bathroom or a snack break.
What's the reasoning behind not permitting Zoom meetings in addition to the phone call?
I believe they're concerned about security. Our courts are super concerned about that right now. We had a telephonic invitation to speak with our judges in the Richmond division earlier this week, and they told us that they were extremely concerned about security issues. They are looking into platforms that might down the road be used for hearings, but as of now, it's all telephonic.
I guess the only comment I would have, this is Kelly Hagan, is I find it interesting that, you know, these are open meetings. Anybody could come sit in your courtroom and listen to your hearing. So as long as you're not displaying PII, personally identifiable information on the screen, I think it's interesting that there are those concerns about security. And I would note that Zoom has enacted various measures or safeguards to address some or all of those security concerns, for what that's worth.
And this is Gary.
I would not be surprised if this extends to a lengthy period that isn't reevaluated.
And this is Gary. The Zoom has undergone an extensive amount of enhancements to their program in the nature of security. And so one thing, if you are using Zoom, what you should do before your 341s is, and well before it, because it could take a while, but you should do the updates, because they're pushing all these updates out that are making the system much more secure than it was when, you know, this whole thing started before COVID-19.
Good point. Jennifer, do you know if we're able to do polls?
I think we can do the polls, and if you want, we have a few quick questions if we want to address them.
Sure, why don't we address those questions and then launch into a discussion with Lynn about subchapter 5s.
Perfect. So one quick question: how should we handle identification when pro se debtors only appear by phone?
Well, I could answer that. I had all of the pro ses actually uploaded their IDs to me by email. I didn't have a single pro se that I had to reset because they didn't have their IDs.
So then, Tamara, you just asked them the question, is the information you provided me, you know, true and accurate IDs for you? I mean, that kind of thing, to kind of connect the dots.
Yes, exactly. I said, can you describe the IDs you provided to me, and are the IDs provided true and correct copies of your driver's license and social security card?
Mm-hmm.
Excellent. Jennifer, another question?
Yes. So region 1 and 2, that was just a comment that region 1 and 2 are telephonic only. And is the telephone encrypted end to end? It's one of the questions.
The telephone system provided by the U.S. trustee isn't encrypted at all, and most telephone systems are not.
I think that was it.
Mr. Persing is raising his hand, and I'm really reluctant to call on him, but maybe we should. Let's see, how do I do this?
Should be unmuted now.
Mr. Persing, are you there?
I am there.
Do you have a question or a comment?
I attended a couple 341s, and I thought they went extremely well. People who dialed in with the phone numbers on the Zoom ones were a little difficult to identify, but otherwise, I thought the trustee handled them very well.
That's
Thank
great
you.
to hear. Yeah. Anything else before we launch into a subchapter 5 conversation? Jennifer, does that?
It looks like that was it for the most part. There were some comments about others are doing telephonic meetings scheduled through July 3rd.
Great, thanks. Jason, do you want to introduce the subchapter 5 NABT committee? Sure.
Sure. I think I mentioned that on the phone, on the line, is Lynn Tavener, and Paula Barrett, and Tamara. The three of them are the brand new, newly minted subchapter 5 trustee subcommittee. It's a mouthful of NABT's board of directors. So we appreciate
Thanks,
all the work
Jason.
you're doing.
Thank
Go
you,
ahead.
Jason. This is Lynn Tavner. I'm the chair of the committee. I have been a Chapter 7 trustee since longer than I'd like to admit, in the late 90s, and have been involved with NABT. And then when I also, in my other life, I'm a Chapter 11 attorney. So I became very interested when I learned about this subchapter 5 that was coming about, and reached out early on to Jason about whether there was going to be any type of platform within NABT with respect to subchapter 5 trustees, because I certainly saw that as a great fit for NABT as well as subchapter 5 trustees. And Jason certainly was receptive, and we have put together the new subchapter 5 committee. And if those of you who are on the line today, if you have joined NABT, great, welcome. And we are working on formulating other materials, potentially a separate listserv with respect to subchapter 5 issues. We are looking at putting together a boot camp specifically for subchapter 5 trustees, because candidly, I have been involved and looking at various programs across the country with respect to subchapter 5. And while there has been a lot of programs, the majority of it focused upon the standpoint from the debtor and or the creditor, but there really was not a focal point with respect to the trustee. And I believe that that is an area that many people would certainly like to collaborate, and that's what we believe that we'll be able to do with this subchapter 5 committee. For those of you that are on the call that are subchapter 5 trustees, or just interested like me as a chapter 11 practitioner, please, we welcome your involvement. And if you're a subchapter 5 trustee and have not joined NABT, please do. We welcome you. And I believe Jennifer or Jason can confirm this, but I believe that for the first year, you would be invited to join without having any type of fee. Is that true?
Correct.
Jennifer, why don't you run down how that works? That's important.
So if you are not a member and you are a brand new subchapter 5 trustee, or even a brand new chapter 7 trustee, you can go on to our website, click on the membership button, and select join now under the trustee membership type. Enter in all of the information, and one of the important things is to enter the year you were assigned as a subchapter 5 or a chapter 7 trustee, and that will and that you are have been approved as that type of trustee, and the system will basically automatically generate a free membership dues for the rest of the year. And then once we get your application, we will confirm that you are in fact appointed, and we will approve your membership.
That's great. Thank you, Jennifer. We look forward to NABT being a great resource for Subchapter 5 trustees. Also with us today that has not spoken yet is my law partner, Paula Barron, who does practice Chapter 11 with me in Richmond, as well as she serves as my counsel in Chapter 7 cases, and also has recently been appointed a Subchapter 5 trustee in the Eastern and Western Districts of Virginia. So she will be talking with Tamara and Kelly a little bit more today about specific trustee items. Before that, I would like to just throw it out there. We had hoped to have some polling with respect to the types of cases that people are involved in and what fashion as far as counsel, trustee, creditor.
We can do that, actually. I think I can launch the first poll if you'd like.
Yes. So the first poll is, what type of trustee are you?
Yep, so we're just waiting. We've had quite a few people respond. I will give them a minute to everyone to get their answer in, and I will close it in just a second. Still have quite a few people jumping in there with their responses. All right, looks like that's most everybody. There you go. So you can see you have a decent mix of people. We mostly have Chapter 7 and Sub 5s on the line. And I can move to the next poll here.
Yes, please.
There we
The
go.
next one is, have you been involved in a Subchapter 5 case that has been filed? And while people are answering, I will go ahead and tell you that I have personally, as Chapter 11 debtors counsel, currently my firm is counsel to a Chapter 11 Sub 5, a real estate holding company that leases to a group home. That case was filed probably less than 30 days ago. So we are in the initial stages. We have had the 341 meeting. We also are counsel to husband and wife individual Chapter 11 sub-type debtors who the majority of their debt is business debt that was related to a failed relationship, franchise or franchisee relationship. So we have the answer. Jennifer?
Yep, so about 39% have been involved in a Subchapter 5 case, and about 47% have not, and 15% not applicable because they are probably either not, they're probably not Subchapter 5 trustees.
Sure. Let's go ahead and do the next poll question. For those of you that have been involved, in what capacity is that? My firm is involved in one other Chapter 11 case in which we represent several Chapter 11, regular Chapter 11 debtors. It's an outdoor retail establishment, but the nuance that relates to Subchapter 5 is that the owner of the various entities is himself in a Subchapter 5 of Chapter 11.
Give a couple more seconds for people to answer this next question, and I think most people have answered, so we will close and share. And it appears that we have about 46% that have been there as have participated as a trustee, 2% as a debtor attorney, 5% as other, and the other half have not.
Well, that's great information from that poll, because it sounds like then that we should focus our attention on the subchapter 5 trustee specifically and that role in the cases. So I am anxious to hear from Paula and Tamara and Kelly to give an overview of what you have experienced so far.
Hi, everyone. My name is Paula Barron, as Lynn indicated. I'm practice in Richmond, Virginia, and I come from, anybody who knows me knows that I come from a sports-oriented family, and so a lot of my perspective in life is sports-oriented. And I sit here today amongst these 3 seasoned veterans who I think have been trustees for decades, feeling like the rookie in the group, because I think I've been a trustee now for a little over 2 months. In comparison, you know, I'm not even sure if I know how to dribble a basketball compared to them dunking, but nonetheless, I'll do my best. In those 2 months, I have already been assigned 2 cases. Interestingly, I serve in both the Western District of Virginia as well as the Eastern District of Virginia, specifically in Richmond and Norfolk. The state has been cut in half. So our panel is the Western District and then Eastern District of Richmond and Norfolk. My first case I was assigned was an individual out in the Roanoke area. It started as a sub 5, the 11. It involved an individual who was having difficulties with a failed construction contracting company. And it appears from looking at plan issues now and working with debtors counsel on those plan issues that the filing was precipitated by majorly a dispute with one of the customers. And that was the driving factor for the need to file that 11. In addition, I'm serving as the sub 5 trustee in a case that's in Norfolk, Virginia, involving two individuals having financial difficulties from a failed food franchise. And that case started off as a Chapter 13 that then converted to 11. And after the conversion, the petition was amended to elect the sub 5 status. And looking at that one, you know, similarly, it was the failed franchise debts that really caused all the financial issues for the individuals, and therefore the sub 5 conversion and then amended petition. One interesting issue with that case right off the bat, and a reason why I was not appointed right away, the UST reached out to me to find out if I had any conflicts, and I did my certification, but it wasn't initially filed with the court, and I wasn't appointed because the U.S. trustee itself, as well as the court, and giving other parties an interested opportunity to chime in as to whether there was an eligibility issue associated with sub 5, given the fact that these 2 individuals now were no longer quote unquote engaged in the business activity. However, the business activity was what caused their financial difficulties, and clearly, without a doubt, more than 51% of the debt arose from those failed businesses. But after vetting that issue, neither the court nor the U.S. trustee's office objected to eligibility, and nor did any other party in interest. And so I was appointed, and it's now moving forward as a sub 5 case.
How about you, Tamara? You want to tell us about the specific cases that you are involved in as a sub 5 trustee?
Sure. I've actually been appointed in 4 sub 5 cases at this point. 3 of them are in the Northern District of Georgia, and 1 is in the Middle District of Georgia. In our region, I assumed it was the same everywhere, but the appointment for people in Georgia was a statewide appointment, and they made it clear that we could be appointed in cases anywhere in the state. But the reason that I got 1 in the Middle District immediately was because it was filed by another sub V trustee in the Middle District, and he was the only one who had passed all the background checks. So I don't expect that I'll routinely get cases in other parts of the state. But let's see, that one is a grading company, and it's actually doing very well. They had been struggling because of the weather and had grown a little too quickly. And because it had rained so much, they were unable to keep up with the payments on their new equipment that they had bought. But fortunately, they were still able to work despite the pandemic, and it got sunny and warm. So they're doing quite well. And I've been able to contribute substantially in that case because some of the creditors who represented some large vendors didn't really know much about sub-V cases. So initially, my role was in explaining to them the differences and that they didn't have quite as much leverage as they would in a normal Chapter 11. And I felt like I actually brought some value to that case. Two others are a medical spa, day spa, and the individuals that own the medical day spa. And those two cases were precipitated by, they decided to expand and open a second location, and construction overages and delays cost them a whole lot. And they were really facing some foreclosure and some other issues. Unfortunately, I don't think either one of those cases are going to make it. COVID, of course, shut the businesses down completely. And given as much difficulty as they were having before all of that, it's really unlikely that they're going to come out. Interestingly, in that case, it's pending before a judge who won't do any telephonic hearings. So it seems to just be stalled. We were supposed to have had the first status conference 2 weeks ago. It's now been delayed until next week, and all indications are he's going to move it again until we can do it in person. So I'm not sure how that works with all of the statutory requirements for speed in a sub-V, but that's where that one is. And then the fourth case that I have is a church, and they were facing foreclosure on their real property and filed right before their annual drive for funds, which happens in March and April, culminating in Easter. Well, you can imagine how that went with the pandemic and the inability for churches to get together. They haven't collected nearly as much as they anticipate. So in that case, I believe what they're going to propose is a cram down, which is just a balloon. So that one is looking like I'm going to be in it for the next 5 years, but we'll see. There's not a lot of creditors in that case, and there's not a lot to work with. So I haven't done that much. And those are the 4 I'm involved in.
Well, certainly a variety. Kelly,
Absolutely.
what have you seen out in Michigan?
So I'm technically on my second case. My first was, I think it's the 14th largest movie theater chain in the country, filed by an inexperienced bankruptcy counsel, and he elected inappropriately subchapter 5. So I knew I wasn't going to be in that case for long. There is a very brief opinion out there from our court terminating my services. And there is a footnote in there where he questions why the U.S. trustee didn't simply appoint themselves, given that they knew this was not likely to be a long-term appointment. So my first real subchapter 5 case is a pharmacy. So perhaps I'm lucky that way. It was filed on March 10th. So just shortly before we had our stay-at-home order entered in Michigan. Small town pharmacy. There was a nonprofit that came to town and is in a sense competing with him on some sales. He ended up financing his company by using these online lenders and has racked up about, I think, $600,000 in debt with these online lenders that are claiming a security interest in his accounts receivable. It sounds as though they're very aggressive. They're very difficult to get a hold of. I think it's looking likely that we won't have a consensual plan, but we're not at that stage yet, so I can't comment on that yet. Sure.
Lynn, this is Gary. We have a few questions that have cropped up, so if you don't mind, I'll butt in here and ask the questions.
Sure.
We have one question from a trustee asking that he's surprised to learn that several other Chapter 7 trustees have been appointed as Subchapter 5 trustees. They were told in Region 2 that the U.S. trustee would not be appointing Chapter 7 panel trustees, and we're looking for individuals with a different skill set. Can you comment on whether this is a common policy in other districts or not?
Well, I can only speak to our district, and we have 2 that serve in both capacities. So I do think, and it was advertised that they were looking to have a variety of skill sets. And I believe that they, for the most part, did interview and pick people that did come from different backgrounds, some totally just accounting backgrounds, some from Chapter 11 huge mega firms, others like Paula from our firm who has her MBA and is a Chapter 11 attorney for mid-sized firms. But I can't comment other than our area. Anybody
Lynn,
else?
Lynn, how many were appointed in your district?
6.
6. So 2 of the 6 are 7 trustees.
Yes, 1 in Richmond and 1 in Roanoke.
In the Western District of Michigan, we have just 3 of us, and 2 of the 3 of us are 7 trustees. And interestingly, one of the judges at a recent seminar questioned the ability of the 3rd trustee, who is not a lawyer, but I would consider a restructuring receivership type expert, questioned his ability to appear in court on certain matters that may be of legal nature without counsel, and how that was consistent with keeping the cost, the administrative expenses low in these cases.
And
So
I can say
Leslie Gladstone also offered that in their area, and not the Ninth Circuit, they were also told the same thing about not using Chapter 7 trustees. So it looks like there's a pretty diverse opinion among the U.S. trustees offices across the country, which is kind of interesting to me because from each of your descriptions of what you've been doing, I noticed skills actually being referred to as skills, or actually skills of Chapter 7 trustees being employed in almost all the cases you've talked about. So that's an interesting dynamic there. Another question that's been asked is, do you believe that the sub-V trustee will typically be the Chapter 7 trustee if the case should convert?
Let me answer this, and then let's go back to Tamara on what they did in Georgia in terms of appointments. But in our district, we've been told that the expectation is if you're a panel trustee, it's likely you'll get the case upon conversion.
we've been told the same thing in Region 21 as well. And what I was going to say about the sub-V appointments in this region was what we were told was that Chapter 7 trustees would not be given any special consideration for the sub-V appointments. The skill set was not what they were looking for. What they were looking for was someone who had some business experience. And I think that they considered my background in Chapter 11 work and in running a small business myself as it sort of put me over the top in getting the position. I don't think my 7 background did play a role, but Gary, I would agree with you that my experience as a 7 trustee has helped me greatly in this, and I think I would be a little bit lost without that background.
Mm-hmm.
Yeah. And then one last question, I'll let you guys get back to your originally scheduled program. How many hours ballpark do you anticipate the Subchapter 5 requiring for you on an average?
This is Tamara, and I can say that I think that's almost an impossible question to answer.
Yeah.
I have 4 cases. In one, I've done virtually nothing other than initially work with the debtor and talk to them about what their plan is and to attend the 341 and the IDI. And in another, I've been very active, and debtors counsel and I practically have each other on speed dial. So I think it's going to vary widely with the case and what's actually needed in each case.
I think that's true for me as well.
I completely agree from the trustee perspective, as well as then dealing with my panel trustees, people that in the cases where we're 11 counsel, it all depends upon the needs of the case. I think one thing from our jurisdiction is all the trustees spoke about it, and then it's like, you know, we want this to work. We understand from the U.S. Trustee's Office, they want it to work, the judges want it to work. So we're very mindful of the time we're putting in and making sure we're not being duplicative of the debtors counsel in their role. I know that was initial concern that I heard from some debtors counsel out there of, you know, are we just going to be duplicating? Is it just going to be an unnecessary cost? So in my jurisdiction, we're all very conscious about that and really coordinating and working with debtors counsel to make sure that we're fulfilling our duties, but not having that unnecessary duplication.
Well, let's talk a little bit about those duties and the things that you all do on the front end once you learn that you have been appointed in a specific case. Paula, you want to tell us about one of the first things you do?
Well, the very first thing that happens, of course, is after my certification in the 11 arena, there's always the IDI with the representative from the Office of the United States Trustee. That is still the same in the context of at least in our jurisdiction, in the context of the sub-5 world. And that IDI is still conducted by a representative of the Office of the United States Trustee. In our region, it's usually the bankruptcy paralegal, not even necessarily the U.S. assistant, U.S. Trustee and or the bankruptcy attorney. It's really the analyst. But the sub trustees are there as well and are asking questions, learning as much as you possibly can about the case, about what the issues are and who the players are. We're also, you know, technically supposed to review the docket, but I will tell you, I learn more at the IDI than I do about reviewing the docket because usually the docket's minimal. Kelly and Tamara, are those similar experiences with you all in connection with the IDIs?
Yeah, I would say the first thing though is I call debtors counsel. You know, what's going on? What's the plan? What got you here and what's the path out? Even before the IDI.
Agreed. Oh.
We have ours very soon. Our IDI is usually day 2 or 3.
Oh, wow.
Oh, yeah, ours are not that quick.
No. I think ours
This
was
is
fearful.
Jason. I have a question for the panel. And the hour is going by so quickly and it's so interesting. But I've been asked by several people over the last several months, how do the trustees get paid in these cases? It seems like it's not clear. So I'd like the panel to answer that as to what you believe is the correct compensation scheme, but also answer the question, have you figured it out in each case, and do you think about getting the judge in the case, or at least the U.S. trustee, to agree on the particular scheme that will be employed in the particular case?
Scheme for compensation, Jason?
Yes.
So in our district, Western District of Michigan, when you file essentially your acceptance, I think it's called a verified statement or something like that, you put in there what your hourly rate is. And it's expected in our district that we're working on an hourly rate. And I think that's consistent with my reading of the act, is that we're not subject to the commission structure in 326.
Okay. Anyone else?
Well, and it's, I believe the way it's supposed to work is that if you have a consensual plan, the sub-V trustees' fees are paid in full at confirmation, like all the other administrative expenses, and they're paid over time in a non-consensual plan. And the sub-V trustee stays involved for the 5 years after the confirmation in a non-consensual plan. And frankly, I think that's the carrot for the sub-V trustee to try to get a consensual plan. You know, we don't want to get paid in drips and drabs over 5 years. We'd much rather get a lump sum and be done with the case.
Mm-hmm.
And I think it's also important to note the hourly rate sort of gave people pause when I was first appointed in cases. And I know that when the UST appointed our pool of trustees, she made it very clear and wanted a commitment from all of us that our fees incurred during the case would not become an impediment to confirmation of a plan. In other words, yes, we're billing at our hourly rate, but there has to be a reasonableness component to it at some point.
All right, so how is that set up at the beginning? Do you do something like an employment application or just a
No,
statement?
as Kelly said, when we accept the appointment, we file where we give a document to the U.S. trustee that's filed by the U.S. trustee that says that we accept the appointment and our hourly rate is X.
Nice.
And then at the end, we'll file a fee application.
And what about interim fee applications? Is
I
there
don't
any
think they're
prohibition?
included. But I think the idea is that the case is moving so fast that by the time you get an interim fee application filed, you're probably at plan confirmation or dismissal or conversion stage.
All right, Lynn and Paula, do you have any thoughts on that? Are you there?
Kind of. Lynn and Paula?
Wonder if we've
Oh,
lost them.
we have, she's
Uh-oh.
on mute. Lynn and Paula, can you hear us?
So one comment I'll
Hello?
make while we're for Lynn to chime in is, if you look at the act, it's very interesting in that it contemplates that the trustee would have funds on hand at the time that the plan has been confirmed, like so just prior to plan confirmation. And yet the act doesn't talk about how the trustee receives those funds or why the trustee receives those funds.
If
But
the
there's a-
case is dismissed, how do you get paid? Leslie Gladstone has that question.
Yeah,
I
that's a
don't-
really good question.
Is that important, Leslie? Oh, okay.
So here's a pointer for subchapter 5 trustees out there. I think if you have a case with first day motions and a cash collateral budget is included in one of your first day motions filed by your debtor, I think that you insist that the cash collateral budget include a budget for your fees. I am contemplating in the future pushing that there be a separate account opened and that professional fees are escrowed into that account, especially if you have a case where all other administrative expenses are being paid during the course of the Chapter 11 prior to plan confirmation, but the trustee or the debtor's attorney aren't. I think there's a good argument that everyone should be treated equally. I think it would also be worth exploring the idea of having the monies paid over to the trustee. Again, I think the act contemplates that prior to confirmation, the trustee has come into some money, and the act does specifically say that I think if the plan is not confirmed, that the trustee can withhold funds necessary to pay the trustee fees prior to turning them over.
Yeah, Kelly and I have talked a lot about how we get paid in these cases. And the idea that Kelly just articulated is one that I really like and think I'm going to try to incorporate as well going forward.
Sounds reasonable. I mean, certainly in all other Chapter 11 cases, the budgets include professional fees. And I don't see why it would be any different here.
There is a small follow-up or similar topic. If a case is changed from a sub 5 to just a Chapter 11 and you are dismissed as trustee, is it best to just not ask for the payment or payment for hours worked if there is very little money available?
So that's effectively what happened in my first Sabre case. And I just decided, given the amount of money or time I had into the case, I wasn't going to pursue being paid. But I think I was only in the case for about a week. And
Hi,
I knew
this
it
is
was,
Len. Can you?
Lynn, are
we
you
can
back?
hear you.
Lynn?
Can you hear me again? It's Lynn.
Yes.
Yes.
Yes, welcome back.
Thank you. Paul and I both, for whatever reason, lost the connection and have dialed in by phone. So I apologize. I don't know what happened. But it sounds like you all were having a very stimulating conversation on compensation.
There's another question about what do you see as a potential with the volume of cases after the increase to the $7.5 million point?
So Kelly, we had a discussion today, a virtual town hall meeting with our court, and we had about 100 participants. And there was a lot of chatting going on, a lot of discussion about the time frame for when we might see some uptick in cases. And what the debtors' attorneys who were involved today seemed to speculate was that you're seeing some business owners try to save their businesses by clearing out their retirement accounts, et cetera. And the sense seems to be that if we're going to see an uptick in cases, whether it's Chapter 11, SABRA, or 7s, it's probably going to be towards the end of the summer. At least that's the sense in our district.
This is Lynn. We've also had a substantial amount of calls from business owners who have applied for the stipends under the new law and are looking at potentially getting that money and maybe utilizing it in the context of a Chapter 11.
Yeah, I'm actually very excited at the prospect of a higher quality of cases going forward, given the increase in debt limit. You know, 2.5 million in debt is not, or 2.7 million in debt is not that substantial. So I think with the increased debt limit, we're going to see some much bigger, more viable 11s coming into this arena.
I think part of what's going to keep people from filing anytime in the next couple months is how do you begin to propose a plan when no one really knows where things are going at this point in terms of reopening and you know, with businesses like restaurants, maybe you can reopen, but you can only have 20% of your seating utilized at any one time.
Well, one thing we know is the world is going to be quite different, and it's going to evolve slowly. And we just don't know how this is all going to work out at so many different levels.
Right.
But what we do know is that bankruptcy lawyers, bankruptcy trustees like us are going to be right in the thick of it.
Some questions that came up before the meeting today. One of them is, are all of these cases designed to confirm a plan of reorganization, or can some of them become liquidating 11s?
This is Paula Barron. I think the answer is yes. I was on a webinar where two judges were speaking about this, and in connection with the plan, it can be a proposed reorganization, but in the plan you have default provisions that in essence are your wind down if certain parameters aren't met. And so it's a reorg, and then by default, if you can't meet your goals, a liquidation, and that's all done pursuant to the plan. And there doesn't necessarily have to be a formal conversion and a liquidation under 7.
There's been a comment by one of the in the audience that it's all going to work out. Bankruptcies are going to go through the roof. We should all get ready.
I think that's a fair comment.
I think that's right. That's absolutely right. And we have another comment that payment for dismissed cases, in our district, a judge has indicated that sanctions could fund the trustee's time. What do you think about that?
Sanctions for what?
I guess for filing a improper case. I don't know.
Very creative.
I think it's going to be really important that we all share opinions that are issued or ideas that we come up with in terms of some of these issues, especially compensation, because I do have some concerns that we might get compensated in just a share of the cases that we administer. And as 7 trustees, we know that happens with IFP cases, but I don't think that we should bear the brunt of the losses that might occur in these cases.
I agree, and I think it's worth mentioning. I know that NABT is working on setting up a listserv specifically for sub-V issues. And I think the sooner we can get that running and get everybody who are involved in these cases on that listserv, the more we're going to be able to share these ideas and discuss options and ideas and make sure we can get paid in these things.
Absolutely,
Very
that's
soon there will
critical.
be-
And the listserv is something that we want to get operational as soon as possible, because it certainly makes sense to have the benefit of as many subchapter 5 trustees as possible. And, you know, you all are on the cutting edge here and have the ability to make some cutting law, but also to make the system work. So I'm looking forward to prospects going forward and getting the committee and the listserv up and running.
We have another question. If a sub-V trustee shall perform the duties of a trustee under 704A2, which requires the trustee to be accountable for all the property received, what does that mean in the context of this case? Does the trustee take custody of assets? And if so, how and when?
I think it's a depends answer. So in my case, if we had a consensual plan, I would not expect to take control over any property. If we don't have a consensual plan, you know, the Act does provide what is property of the estate. And I think you have control over more money. So I think you become a little bit more like a Chapter 13 trustee at that point in terms of property of the estate issues.
It also leads into the question of liability. I
Yep.
remember many years ago, there was a trustee who was a Chapter 11 trustee, and the business was operating, and he allowed the debtor to continue operating a restaurant. Well, the debtor didn't make the tax deposits. And ultimately, the IRS came after the trustee saying, hey, it was your responsibility, even though it was all authorized the way it was set up. Ultimately, there was a settlement, I think, of some sort. But these are questions that are going to have to be worked out. And hopefully not the hard way.
Chapter 5 trustees have separate insurance to cover them for their activities?
Yeah, good lead in, Gary. There are policies that will cover your activities as a trustee. And I know that the 5 other sub-V trustees in my region that were not previously trustees, I certainly mentioned to all of them that it would be a really good idea to get insurance for your activities.
And you do that as a rider to your attorney liability or?
Yes, exactly.
Policy?
And for people who aren't attorneys, you can get a separate policy.
Have any of the subchapter 5 trustees actually received a dime yet?
No.
No.
No, but in
It's early
fairness,
yet.
this hasn't been around long enough for us to get to that point.
Right, okay.
Well,
No,
Gary,
I've only had
Gary, on
my
that
status
note,
conference. I'm sorry, go ahead, Jason.
no, you finished, Tamara.
I was going to say, I've only gotten to the point of a status conference in one of the 4 cases that I've involved in. So we're not quite to confirmation, which is the first point we have to get paid.
Hmm.
Can a sub-5 trustee hire professionals?
Yes. I think
Yeah.
you have to do so very carefully because, again, the whole focus is keeping the administrative expenses down. And the U.S. trustee is going to be watching that like a hawk. And I think the court.
And also, I don't think there's a whole lot of need for it. If you need an accountant, it's really the debtor that should be employing the accountant.
Correct.
There's ideally you don't need one.
Well, it's a whole new world, and it's interesting. For every answer to a question, it just raises more questions. And ultimately, it'll be the experience of all of you that will really inform the future of how this goes. There was a lot of skepticism about the whole Subchapter 5 process, but it's exciting, and it can really go in the right direction. It could really be helpful in the upcoming surge that we all suspect is really right around the corner. So it's now 5 o'clock, 5:01, and I want to thank the panelists. It was, again, a very quick hour. It's fascinating. It's obviously a subject that we're going to have to have more sessions on. I mean, this is something that's going to go on and on. NABT is committed to developing a knowledge base with respect to Subchapter 5. We're committed to supporting Subchapter 5 trustees. And so it is now, again, the 5 o'clock hour. That, you know what that means. And at 6 o'clock, hopefully all of you on the phone, rather who are tuned in, whether you're on the phone or through your computer, there's 91 of you still who haven't hung up yet. Hopefully you'll come back at 6 o'clock for the virtual happy hour. I can tell you the last one was a lot of fun. And once again, thanks everyone. And we will see you all and talk to you all very soon.
Thanks, everyone.
Thank
you.
Thank you.
Thank you.